May it please the court, my name is Radford Dimmick. I represent the appellant, who is Morgan Miller, and she's the mother and guardian of Normandy Miller and Madison Brown. I'd like to reserve 3 minutes for rebuttal.
All right.
Your Honor, please, may it please the court, this controversy essentially comes down to the propriety of a sale of a parcel of real property here in Davidson County on 3952 Drakes Branch Road in Nashville. The defendant in this matter is James Wilson, and he was appointed under the terms of the last will and testament of Ruby Smith to sell that parcel of real property for the benefit of Normandy Miller and Madison Brown. Mr. Wilson took possession of it by way of a deed that was sent to him to hold as custodian for these two, and he sold it for an amount that my client would show that is less than the fair market value of the property. A suit was brought, and a lot of the factual allegations as they relate to the sale are not in dispute. Mr. Wilson admits that he sold the property for $215,000. Mr. Wilson admits that he consulted the office of the tax assessor of Davidson County as a basis for propriety of that sale. Mr. Wilson also acknowledges that he does not have any experience in the area of real estate transactions, yet he did not consult with a real estate agent or expert to determine the proper value of the property. After he sold the property, well, as a result of him selling the property, approximately 8 days after the sale took place on April 15th of 2021. 8 days after the sale took place, it came published with the tax assessor's office that the value for purposes of a tax assessment was about approximately $142,500 more than what the property was sold for. Both parties engaged in experts. They had testimony that was presented to the court, and the ultimate issue before the court today is that the trial court made several factual findings in which they said, the court, Judge Briley at a bench trial, established a factual basis that Mr. Wilson breached his fiduciary duty. Despite these findings of fact that he made, the ruling ran counter to that. For example, in his findings of fact, one of them was that Mr. Wilson was going to hold the property when he initially got the property, and he was going to allow his sister to live there for a year. Upon protest by my client that this was going to happen, he promptly sold it to a family friend. Conspicuous in this is on the date of the trial of this matter, this family friend who wound up purchasing the property had allowed Mr. Wilson's sister to reside there. These suspicious circumstances were one of many that were cited by the trial court that eliminated the notion that this sale was a result of an arm's length transaction. The property was sold to this family friend for, as I said, for $142,500 less than the appraised value of the property. He failed to employ a real estate agent. He failed to list it to the general public for a fair market sale, and he failed to get any professional opinions to sell the property. His only experience, and this was a finding by the court, his only experience in selling the real property, in any real property, was one parcel that Mr. Wilson himself owned personally in Georgia, and even then, he had the wherewithal to hire a real estate agent to sell it for himself. So whenever he was charged with a duty, a fiduciary duty that's been stipulated to in the appellee's brief, Mr. Wilson had a duty as a fiduciary to sell this property, and he had a duty to exercise utmost care for the purposes of selling the property of another. He didn't even do what he did for himself, and that's get independent advice as to what the proper value of this property would have been. And the net result is 2 minors had to suffer. They have financially suffered in this matter because the amount of money that was brought in was $215,000 when it should have been around $357,000. The fair market value as defined by Black's Law Dictionary, is the price that a seller is willing to accept and a buyer is willing to pay on the open market, not to a friend, not to somebody who's going to turn around and rent out to the seller's sister. In an open market transaction, that wasn't done here. As a result, all of these findings were made by the court. These factual findings were made by the court. And with the exception of what is the proper value, literally all the facts were stipulated to by Mr. Wilson in his testimony, and all of these were found by the court. As a result, but the conclusion the court made that we would say runs contra to the findings of fact, the court found that Mr. Wilson did not violate his duties as a fiduciary, and as a result, Ms. Morgan Miller did not carry her burden of proof by a preponderance of the evidence that Mr. Wilson had acted improperly in this sale. The facts, we're not asking for the court, this court, to rewrite any findings of fact. The findings of fact that were presented in this order are sufficient, we would show, to a finding that Mr. Wilson breached his fiduciary duty. He has a duty to these children. It's a heightened duty. Now, Mr. Wilson complained in court, and it's been brought up in the appellee's brief, that he felt rushed because my client had filed a petition to compel him to sell the property whenever she found out that Mr. Wilson was going to rent the property out to his sister for a year. That's a red herring. It's inappropriate by a lot of different measures. A fiduciary can't go hide behind somebody who doesn't have authority to sell the property and say, well, she made me sell it. No one made him sell it for less than $142,500 less than what it was valued for. He did it on his own.
Mr. Demick, you mentioned what the court found, and I'm going to read you something from the court's findings. Basically, I'm reading from item 9 of the court's findings. The court found, and the court stated, however, there was no evidence presented to the court that proves Mr. Wilson had an ulterior motive, and his explanation that his sister was initially allowed to live there to assist in the protection, cost, and renovation of the property is reasonable, and the court accepts it as true.
Okay, and the court accepted the fact that she was living there for a year as true, but afterward, she's still living there 3 years after the property was sold. And our point whenever we brought that trial was he sold it to a family friend, and the court also found in its ruling that whenever he sold it to a family friend, that in and of itself was a suspicious circumstance in the sale. Correct, that's one of the findings that the court made, but I don't think that voids out the whole notion that Mr. Wilson sold it for far less than the value of the property was worth. But when you take all of the factual findings that the court made as a whole and look at it as a whole, we think it's pretty clear that Morgan Miller carried her burden of proof by a preponderance of the evidence that Mr. Wilson breached his duty as a fiduciary to these two. We would ask that this matter be remanded to the court, to the trial court, with findings that the conclusions made based upon the court's own findings show that there was a breach of fiduciary duty. We ask that the ruling be reversed and remanded to the trial court. We'd ask that Morgan Miller be awarded her attorney's fees under the statutes for breach of fiduciary duty as well.
Let me ask you, is there anything in the record to suggest at the time of the sale that Mr. Wilson knew that he was selling the property for substantially less than the fair market value? I understand your argument about he didn't try to find out the fair market value, but is there any proof to suggest that he knew it was substantially less?
In short, no, because that would imply an intentional breach. We've alleged this is based upon neglect. He failed in his duty to investigate. He failed in his duty to go search out what the proper value was. I cannot represent to the court that he intentionally knew that this was an undermining of the value.
Okay. And he did sell it for an amount greater than the existing appraisal?
Well, when Your Honor says the appraisal,
Yeah.
he sold it for $215,000. The appraisal for the purpose of tax assessment was $210,000 and some change. So yes, he sold it for a little more than the appraisal for the purposes of tax assessment.
Okay.
That's not necessarily what would be the value on the open market.
Would it necessarily be more, or could it be less?
Could be more, could be less. But the fact of the matter is it was more,
Right.
and he failed to go look into it, and the net result is these young ladies have lost out.
Was there any proof presented concerning what repairs were needed that Mr. Wilson proposed that he was trying to do before he sold the property?
There was proof put on by the defendant that there were repairs that were necessary for the property, and I think those repairs were taken into account by both of the appraisers. Both of them had the opportunity to look at the property and assess what was going on with them and what repairs would be needed.
And the amount of those were how much?
The amount of the appraisers,
No, the repairs.
I don't recall what the exact amount of those
All
were.
right, thank you.
Thank you.
Good afternoon. May it please the court, Michael Hoskins on behalf of the appellee, Mr. Wilson. Your Honor, this is an appeal from a bench trial, and as Mr. Demick has reported, the majority of the facts of the underlying appointment and of the custodianship of Mr. Wilson to sell this property on behalf of these minor children is not in dispute. Some of the circumstances that are, however, in dispute, or they're not in dispute in the record, but they're not mentioned by the appellant. The circumstances attendant the sale, the salient facts and circumstances attendant the sale, which are in the record, just are not mentioned by the appellant. At the time of Mr. Wilson's appointment, he lived out of state in Georgia. He was tasked with the unenviable position of selling his grandmother's home for the benefit of her minor children. The undisputed testimony at trial was that for many years, the property had been poorly maintained and had fallen into a state of serious disrepair. The undisputed evidence at trial was that the basement constantly flooded. There were plumbing issues, electrical issues, termite problems, holes in the walls, holes in the floors, cracked bathroom tiles. Whenever you used a shower, it would drip through the floor, saturating the structure of the building and dripping onto the basement floor. That there was black mold all over the basement ceiling, which had partially collapsed. The expert that was retained by Ms. Miller actually found that there was also holes in the roof, holes in the carport, and so Mr. Wilson determined that the house was almost uninhabitable. His testimony at trial, which is in the record, that it was in shambles. Even the appellant testified that she thought the house was in such state of disrepair that it was, quote, unsafe for anybody to live there. So he's got the task of selling this house. He proposed a plan to try to make some repairs to the house. The extensive repairs were necessary, so he contacted the appellant and said, this is my plan. My plan is to make some repairs to the house and put it on the market so it can be sold, so we can get a good amount for it. And he wanted his sister to live there because the house was vacant and she could sort of manage the inflow and outflow of contractors coming in to make these repairs because he lived all the way out of state. Well, he'd only been in possession of the house for 39 days before he receives a petition filed by the appellant asking the court to order Mr. Wilson to sell the house promptly. At this time, he's making repairs, some minor repairs to the home out of his own pocket. Now he's got to hire an attorney to respond to the petition. He was under the impression that the appellant filed the petition requesting that the court order him to sell the house promptly because there was a need for funds quickly. And so at this point, his testimony in the record is that his focus changed. His focus changed from getting these extensive repairs done to now looking for a buyer. Now, considering the deteriorated condition of the property and considering the fact that all these extensive repairs were needed to be made, he elected to sell the house as is. And finding an as-is buyer is a lot different than putting your house on the market with a reputable real estate agent where you've got buyers coming in asking for repairs to be made. Had he taken that course of action, he certainly would have had disclosed to any potential buyer that there were termite problems, there were foundational problems with the house, the ceiling was cracked and separating in the living room. All of these problems and defects with the property that he was aware of would have to be disclosed. And so in an effort to quickly sell the house, he did locate a buyer. There were several buyers that had made inquiries about buying the house. None of them had offered more than $200,000 considering its condition. He did review the tax assessed value, which at the time was $210,700, in negotiating the sale that he finally arrived at for $215,000. At the time, there was no $357,000 valuation of the property. All you had was the valuation then current at the time. It just so happened that 8 days after the sale, the tax assessor's quadrennial reappraisal of properties came out and increased the valuation to $357,000. But that increase in valuation doesn't necessarily take into account the particular attributes of this particular property and the deterioration that this particular property had suffered. And so those are the salient facts that are not recounted by the appellant, which were testified to and are in the record, and which the trial court referenced in its findings. And so when you look at the determination that the trial court made, it has to look at the circumstances attendant the sale that Mr. Wilson considered at that particular time. At that time, he knew that he didn't have the wherewithal to respond to this legal proceeding, and so he made the decision that I'm just going to not make these repairs and sell the house as is. The trial court heard this testimony from Mr. Wilson. It was undisputed by the appellant. Even the appraiser that the appellant relied upon at trial, who gave the property a valuation of over $350,000, admitted in his appraisal report and on the stand that he wasn't aware of these mechanical defects in the house, that he wasn't aware of the severe plumbing problems and the electrical problems, and had he been aware of those mechanical issues, it would have impacted his opinion of value. That's stated and cited to the record in our brief. Your Honor, so when you look at the circumstances of this case, there are no factual findings of the trial court that the appellant actually opposes. There are no factual findings that are being presented to the trial court that's being argued that preponderate against what the trial court found. All of the facts took into account the weight of the testimony. The court had the benefit of being able to see the witnesses appear and testify, weigh their credibility, and made a determination based on the facts and circumstances that were presented to Mr. Wilson at that time. Mr. Wilson is being unfairly criticized for events after the fact, in hindsight, and he had no way of knowing if the tax assessed value would go up or down. The tax assessor herself, Miss Honorable Vivian Ouellette, she came to court and testified that no one knows that tax assessed valuation. I mean, we all have had a recent tax assessed valuation where a lot of properties in Davidson County have increased, but there was no way of knowing whether that would go higher or lower. And under the circumstances, the trial court further found that it was reasonable for Mr. Wilson to be under the impression that he needed to sell the house quickly, given the fact that the appellant filed this petition in court asking that it be immediately sold. And so taking those into consideration, the fact that he needed to sell the property as is, he made the decision to go ahead and sell it. But there is no evidence in the record that had he hired a realtor with the house in its present state of disrepair, that they would have advised him to sell it for more than he had. And there's no evidence in the record that a willing buyer on the open market would have paid more for the property than what he was able to negotiate. That's just speculation after the fact to say, well, this is what he arrived at. He actually did what the appellant was asking him to do, to promptly sell it. And those funds would have been immediately available to the appellant's, the minor children. They would have been immediately available had not this legal battle ensued and this appeal. With regard to those issues, the trial court's factual findings are entitled to a presumption, and there's been no argument that the factual findings of the trial court should be overturned, and so they should be left alone in this regard. And in weighing that, I believe that the trial court made the correct decision and that decision should be affirmed. Now, with regard to the second issue, with regard to the attorney's fee issue, there was no proffer of attorney's fees at the trial court, and there was really no argument about whether the attorney's fees should be awarded. There was no indication of how much attorney's fees had been incurred or anything of that matter, and there was no indication that they were the prevailing party, and without them being the prevailing party, there would be no basis for the trial court to disturb that conclusion either. Are there any other questions that the justice may have?
Seeing none, thank you.
Your Honor, we would ask that the court affirm the trial court's conclusion. Thank you.
The counsel is correct, and I stated in my argument, that initial argument, we're not attempting to overturn the factual findings, but the factual findings, and the court found initially set forth a legal standard in its ruling. Mr. Wilson had a duty as a fiduciary to the minor children, Normandy Miller and Madison Brown, when he sold the property, and was obligated to act as a reasonably prudent person making decisions regarding the property of another. The court found, as a finding of fact, that the appraised value of the property upon which Mr. Wilson relied was nearly 4 years old. Only a few days after the sale of the property, the appraisal published by the Davidson County Assessor of Property increased by approximately 70%. This fact is significant evidence that Mr. Wilson acted unreasonably. This is the court's finding of fact. The court went further and found that Mr. Wilson, counsel for Ms. Miller also elicited testimony from Mr. Wilson that he had limited real estate experience, lacked any training that would have made him better equipped than an average person placed into the role of a guardian under these circumstances. These facts should have made Mr. Wilson consider the prudence of a sale that was not subjected to the review of an expert or more generally subjected to test the open market. The sale of the property to a family friend under these circumstances certainly created the appearance that something could be amiss. This fact weighs in favor of finding that Mr. Wilson acted imprudently. Court went on to find the defendant presented the testimony of Ms. Wilhoit, the Davidson County Assessor of Property, who testified that the properties in Davidson County are assessed every 4 years. She also testified that at the time of the sale in 2021, the tax assessed value was nearly 4 years old. This court finds that this evidence broadly tends to prove that Mr. Wilson acted unreasonably, except as stated in 8C below. The court, counsel argues that there was no evidence that it would have sold for more in the open market. Well, that's true, because Mr. Wilson took away the opportunity for it to be sold for more. Whenever he sold it for less than a market value, he breached his duty as a fiduciary. The facts were found by the court in its own ruling, and based upon the facts that were found by the court in its own ruling, we think that's enough to find that Ms. Miller carried her burden of proof by a preponderance of the evidence, and this matter should be reversed and remanded to the trial court. Thank you.
All right, thank you. Sasha, you want to call the next case, please?
Chelsea C. Stewart versus Kyle P. Hester.